Everybody. My name is Josh Damberg. I am an attorney at the law firm of Henningsen and Snoxel. I partnered with Mr. Terry Collins and the Rose Arbor in Wildflower Lodge in Maple Grove, Minnesota last week to give a presentation on medical assistance and specifically elderly waiver. This presentation today, we wanted to take it virtual and offer the opportunity for more people to kind of gather that information as well as a potential opportunity for some continuing education credit. So the idea today is that I'm going to revisit the topic of both medical assistance broadly, and then also dive a little bit deeper into the narrow topic of elderly waiver. So with no further ado, I'm going to give you a little bit of background on myself. There you get to see a picture of me. Of course, I'm wearing a suit and tie as all attorneys do. This is more typical of me, as you can see in the webinar here while I'm talking, but this is me and my areas of practice at Henningsen and Snoxel. So really, my practice areas are two core things. First is estate planning, and second is elder law. And as you'll see on the slides, estate planning encompasses wills and trusts, powers of attorney, and healthcare directives. So that's an estate plan generally. Outside of that, in the elder law sphere, I deal with a lot of long-term care type of planning, incapacity planning, medical assistance or Medicaid planning, which is the focus of today's presentation. And then as a third ancillary thing, I also work in the areas of probate and estate administration. So the first two practice areas are primarily forward-looking. They're planning oriented. The final there, probate, is going to be after death. So it's a little bit different, but it captures some of the mechanisms from the planning process. So to start, I want to do that high level, or what I call the kind of umbrella view of Medicaid. And I'm going to kind of use these terms interchangeably. But Medicaid, you see on the slides there in the parentheses, I have medical assistance. And the idea or the reason that the parentheses are there is in Minnesota specifically, Medicaid is called medical assistance, and sometimes you'll hear it referred to as MA. They use acronyms all over in elder law, especially in this space. So what is Medicaid or medical assistance? Well, specifically, as you see with the first bullet point, it's a needs-based welfare program. But it's not a general welfare program. It's not something where money is distributed. It's specifically designed to benefit people through covered care costs. So what does that mean? It means Medicaid is really designed as a healthcare program. And it is specifically designed as that needs-based welfare component captures for people that meet certain limitations. And what I mean by limitations and what needs-based mean or what welfare means is that your income or your assets must meet certain minimums or thresholds. And once they do so, you may be eligible. So it doesn't mean that everyone has access to Medicaid. If you kind of balance that or think about it with the other well-known and often confused program, Medicare, that's considered an entitlement program. So everybody should have access to certain Medicare benefits. I like to talk about the two programs kind of as a teeter-totter. On one side, the Medicare and the entitlement program, you get these initial benefits at the onset of potential need. However, Medicaid and medical assistance are the other side of the teeter-totter, designed for the needy financially for longer term benefits to provide for care. So my next bullet point says Medicaid is a mixture of federal and state programs. What does that mean? Well, the umbrella theory here, Medicaid is a federal program. It's what the federal government refers to it as, and it's what they designed or created when they put it into law. That's what it's referred to as. Medical assistance is very narrowly Minnesota specific. So Minnesota, just like every other state in the country, had the opportunity to say, okay, there's the federal program. Here are the pieces that the federal program puts out there and encourages or wants to be part of the big federal umbrella. And here is what Minnesota is going to do. So the federal program and the state-based program aren't going to always be perfect mirror images of each other in terms of the requirements and the benefits provided. Also interesting to note is while we call it medical assistance in Minnesota, it could be any number of different names, including Medicaid or medical assistance in the different states that adopted it. So you have to be very careful as you cross borders to make sure you know exactly what you're talking about. This is a huge issue in Minnesota because when I use the phrase medical assistance, most people don't think of Medicaid. They don't think of a government based, needs based welfare program. They think of, oh, I do need help with certain things specific to me. He must be asking me if I need assistance with those medical needs. And that gets really confusing and challenging for people. But medical assistance or MA, whenever I use that moving forward in the presentation, I am always talking about Minnesota's Medicaid program. Okay. So I wanted to really hammer that point home because I'm going to try and be consistent by calling it medical assistance, but you will see Medicaid remaining on my slides. Now that I've touched on kind of the basis of the program and tried to differentiate the fact that it's federal and state and we're talking about Minnesota law here, I also want to make a quick note that if you are someone that is listening to this and you are thinking about or working with people in differing states, because it is adopted state by state, the rules that I talk about, the numbers that I talk about, and the information I'm sharing are likely to be different if you're talking about Iowa or one of the Dakotas or Wisconsin. So be certain to seek out advice that is very specific to your jurisdiction if you have family, friends, you yourself, or you have clients that are receiving care in those other areas. So I'm going to get a little bit more detailed here. But as I said when I started talking about this program, I want to highlight first and foremost the basic eligibility. So that means these 4 bullets that you now see under this basic eligibility slide apply not only to medical assistance, but also specifically to elderly waiver. I'll touch on that more as I transition into the more narrow area of elderly waiver. But for someone to be eligible to receive MA, no matter what program they are receiving it through, because there are a number of different waiver programs, straight medical assistance for long-term care, that every single one of those differing programs, you need to meet these core pieces. So I spend a lot of time reviewing these with families that I work with and making sure that we can, at the very onset of our time together, check off these boxes and make sure that we can prove or demonstrate that we are eligible under these 4 pieces. The first one is residency. You must be a Minnesota resident to receive Minnesota's brand of Medicaid. Terry actually interacted with me recently with a question about this because we had someone that was relatively new to the state of Minnesota. And here's where I want to point out residency isn't a difficult topic. It is pretty black and white or clear. The idea here is that you are considered a Minnesota resident if you have the intent, you can demonstrate the intention to remain in Minnesota permanently as a resident of Minnesota. Things like having a home here, updating your mailing address, updating your driver's license, even simply moving here can be an evidence of that intent. Nowhere in the medical assistance laws or the Medicaid legislature does it show or tell us that you need to have a minimum time period within a state to receive care through that state's program. So residency, typically a pretty easy yes or no answer when we go through that. The second section is a little bit unique, and I didn't put all the details in here. Of course, there's the area of Medicaid and medical assistance is very broad, and there are tons and tons of rules and exceptions to the rules and requirements of people. So I can't capture all that in an hour. But the idea with this basic eligibility is age 65 and older, you are deemed potentially eligible to receive medical assistance. Of course, there are caveats there. If you are under the age of 65, but you have certain care needs, you're deemed disabled, you may be able to access the medical assistance program. However, for elderly waiver, that is specifically for people over the age of 65. So then we flow into, again, that's pretty obvious, pretty black and white. We can typically, by looking at our birth certificates or counting how long we've been on this earth, we can figure out if age 65 is a yes or a no answer. Next is care needs, and this gets a little bit more difficult. So when we talk about care needs, specifically in medical assistance, there's a number of different things that get thrown out there when we're thinking about it and talking about it. We hear all the time the acronym ADLs, activities of daily living. You hear things like cognitive impairment, physical functional ability, and also NIFLOC. I told you there were going to be a lot of acronyms in this presentation. So NIFLOC stands for Nursing Facility Level of Care. All of those things are different avenues and ways that people and the government specifically in this circumstance try to gauge someone's care needs. To boil it down and get away from some of those very narrow and specific acronyms or assessments, the idea behind medical assistance is that you have to be able to demonstrate that you have a care need and likely an unmet care need. So the idea is you can't be an able person that is simply providing for your own care because that isn't necessarily a need. You're making it work on your own or independently. You don't need the medical assistance program. Basically, you have to get over a threshold that says, I cannot care for myself anymore. I cannot provide for my own activities of daily living, excuse me. So that becomes a part of the process for applying for medical assistance is getting those needs assessed, demonstrating those needs, and making sure you meet the threshold, the necessary care requirement to be considered eligible for medical assistance. The final piece, and the piece that I spend a lot of time on, and really where I get most involved in the details with the family, is that final piece there, the financial eligibility. And if I look over here, I apologize. I'm trying to monitor my time to make sure I'm kind of staying in tune with my hour-long thought process here. But the financial eligibility portion of medical assistance gets really well broken down in my next few slides. But I want to link you back to my previous slide because financial eligibility is where we look at the needs-based welfare program, okay? If you have the ability to pay for your own care privately, independently, you will likely never be eligible or be considered financially eligible for medical assistance. So it's really something that's supposed to make up the difference between the assets you have, the income you have, and the overall cost of your care. So how do we look at that? Well, first we do take a look at income. And I don't dive very deep into income here, but if I'm thinking about me as a medical assistant applicant or recipient, the state, the county looks at my income to determine, okay, Josh's income is at a certain threshold and his care needs are also at a certain threshold. They cost so much. So my monthly care costs, I need to be able to demonstrate with some certainty. So it's relatively easy when we start getting into assisted livings or nursing homes because we start seeing, okay, my monthly cost of care is X. And then what I have to demonstrate from an income perspective as someone pursuing medical assistance benefits is that my income is totally insufficient to meet my overall care costs. I can't pay for my care. So I have need there. I have financial need. So I have checked off the first box for financial eligibility if those care costs are rising above my monthly income. Okay. One thing I will note here before I dive too deeply into the assets is that income is very important and becomes part of a mathematical equation that the county goes through for the applicant or the recipient of medical assistance. However, if I'm married and I have a healthy spouse at home or living with me, their income is not as important. My income is the one that specifically comes under the microscope, if you will. As I'm receiving benefits, if I'm eligible and I get on medical assistance and they begin to pay for my care, my spouse's income is not at issue. Okay. So that person can have a growing income, they can continue to work, things like that. And that income won't be attributed to me and force my benefits to be in jeopardy after I become eligible. I'm going to shift now. We've talked about money coming in, income. I'm going to shift to assets. And you'll see on the slide, I really break down, and I guess the state breaks down under the medical assistance rules, assets into three buckets. The two first buckets there, exempt assets and available assets, are the primary one that we see and that we care about and that we walk through as part of planning. Unavailable assets are a little bit of a unique creature, and I'll touch on them, but I won't spend a ton of time within that bucket, if you will. Reason being, unavailable assets are pretty unique in terms of the situation and the county honoring them. And at times they can become available, so they can convert and change. Of course, all of these assets do have the ability to convert and change between those buckets, but most of them are more intentional and we have control over it versus the unavailable assets. And I'll clarify that a little bit once I get to the unavailable asset section. I'm going to start with the exempt assets. So exempt assets are things that I certainly help plan and create because an exempt asset is not counted against the medical assistance applicant or recipient, meaning they can retain or hold those, or their spouse can retain or hold those assets, and they aren't counted against them for purposes of financial eligibility to receive benefits. So, what are the exempt assets? Well, there's four of them, four primary, or four that I will discuss today. The first one is the house, the homestead. If you are able to stay at home, typically your home remains exempt and is not counted from an equity standpoint. The county or the state will not look at the equity in your home and say, okay, we are due the equity in your home. Another interesting thing here is a secondary restriction or limitation on the exempt nature of someone's home. There are equity limits. So I can't go out and buy a multi-million-dollar home and make that exempt, okay? The idea here is that Minnesota, whether it's arbitrary or not, does set a limit in terms of how valuable can that home be if I'm going to protect it from exposure to care costs. And currently in 2021, remember these numbers change every year, but in 2021, the equity limit is $603,000. So you can have a very, very nice home and protect the entirety of that equity from care costs, so long as you or your spouse or potentially another family member can stay in that home. If the equity goes over and above that $600,000 mark, then they are going to be counting a portion of that home's value either against you as the MA applicant or against your spouse. So we would have to do some additional planning there to make you financially eligible. Household goods is my second area of exempt assets. And household goods, I typically describe to clients as the things that you could sell in a garage sale. So things like your furniture, your electronics, your clothing, the stuff that is within your home. Those assets are not going to be counted against you. AKA, the county isn't going to show up at your door and say, when are you having the garage sale to sell all of that excess stuff in your closet? No, they aren't going to go that far. My third exempt asset is one vehicle. And here's a fun part, and a part that a lot of elder law attorneys joke and tease about, because we don't have a lot to joke and tease about when we have these conversations. That vehicle can be of any monetary value. Of course, we live in Minnesota, so talking about getting the convertible or the dream car, the Maserati, that is a fun conversation to have and to daydream with. And technically, you could pursue that avenue. You could protect assets or at least make them exempt for a period of time by purchasing that dream car. You know, I always end up scaling clients back if we get too deep into that conversation, because we obviously want a vehicle that's going to last forever, that's going to meet your needs for driving in a Minnesota winter. That is going to be able to carry the necessary things. If you're staying at home, we need to be able to fit maybe a wheelchair into it. Interestingly, you potentially can have an exempt asset that makes it handicap accessible. So a vehicle that provides for aging in place can become an exempt asset, such as a van with certain needs for getting even a motorized wheelchair into it. The final and fourth exempt asset is prepaid funeral and burial. There is a unique caveat with this. So if you are planning and purchasing prepaid funeral and burial types of things, so if you meet with a funeral home and prepay, or if you meet with an independent provider and prepay before you're on medical assistance, the limits and costs and amount of money that you can put into those policies is a little bit higher. Okay, so you can exempt more of your overall assets for both you and your spouse, and at times additional family members. If you are already on medical assistance, that number shrinks drastically, and you don't have access to pour quite as much of your assets and protect or exempt assets in the same way as if you were doing that prior to receiving medical assistance. So that I've always point out is super important to begin and actually finalize that process. Get the money out of your name and into the policies before you end up applying for medical assistance. So those are the four exempt assets. And again, I'm going to circle back just to hit on it a little harder. Those are not counted for medical assistance eligibility. You may be required to report them and list them out, but they are not reported in terms of being counted against you, making you ineligible. The assets that we care about and that can make you financially ineligible are those available assets, my second bucket there. These are assets that medical assistance determines to be available to pay for your long-term care expenses. So things that you can liquidate and then pay monthly care costs, whether that's in home, in an assisted living, or at a nursing home. If you have available assets over and above that $3,000 limit for the person receiving benefits, you are not financially eligible. So it is a very, very bright line, no exceptions. So available assets, what are they? Well, you can pretty much look at my exempt assets that I walked through and kind of talked you through and say it's everything else. Anything that you have the ability to exercise control over and liquidate. So I do have a little list here that I'm going to read through, and it may go from very obvious to a little bit more nuanced, but cash, stocks, bonds, savings and checkings accounts, other bank accounts such as money market, certificates of deposit or CDs, your IRA or other investment and retirement accounts, 401ks, contracts for deed, life insurance policies that have cash value. That's a little bit of a unique one. The cash value is actually available to you because you can pull those assets out of the policy. Additionally, any real estate property that you own outside of your homestead. So I already touched on the fact that exempt assets include your home, include your homestead. But if you have a cabin, or if you have a property in a southern state where you go during the winter, those additional properties, that real estate is going to be considered available. And what the county would ask of you would be to liquidate that property, sell it off, and get liquid assets so that you use those funds to pay for your care. Finally, I touched on vehicles with the exempt assets, so I would be remiss if I didn't touch on it during available assets. But if you're a household that has multiple vehicles, if you're a car collector and you have a garage full of priceless vehicles, I shouldn't say priceless, but 4 or 5 vehicles, only one can be protected. So you can't maintain all of those vehicles or they will be counted against you. Here's the thing with available assets. If you are a single person, $3,000 is the end all be all number. You must get to that number and below it to be considered financially eligible. If you are A married couple that both of you are applying for medical assistance, that means it's $6,000 total. You each get a $3,000 limit. If you're a married couple and only one of the couple are applying for benefits, there are some special rules that come into play. I already stated that the medical assistance applicant, the MA spouse, can only have $3,000. However, the community spouse or the healthy spouse, the individual that does not need their care paid for, they have something special called the CSAA, or the Community Spouse Asset Allowance. This was something that is specifically designed to make sure the healthy spouse does not become impoverished based upon the care costs and care needs of their spouse that is ill or unable to pay for their care. So again, it's a moving target, but that number in 2021 is starting at, and I wrote it down here to make sure I have the most up-to-date number, is $130,380. Again, that changes yearly, so I'm only an expert for a year. Every year I have to become a student again and relearn it. But the idea is that that healthy spouse, all of those assets that I talked about that were available, cash, stocks, bonds, that spouse can hold on to $130,380 worth of those assets in any way they choose to make them up. So they can protect one of those extra vehicles. They can hold some of the retirement accounts, bank accounts, those types of things, up to that dollar figure. Anything over and above the MA applicant's 3,000 and the community spouse's 130,000 and change will still be considered available and will need to be spent either on exempt assets or care costs. So this is where I get into the idea that you do have, as a married couple, the ability to transition or change the treatment of your assets. So I can take available assets. If I have a ton of extra cash in the bank, I can take some of those assets and dump them into exempt assets. I can buy my prepaid burial and funeral policy. I can purchase a new vehicle or fix up an existing vehicle. I can pay off a loan on an existing vehicle. I also can go ahead and if I look at my home and I have a mortgage on it, or my home needs updates, it needs a new roof, it needs a new driveway. I want to change some things in relation to the bathroom to make it more accessible. I can use my assets over and above that community spouse asset allowance and spend those down or reduce them by purchasing exempt assets. Okay. It's a really important tool as we're discussing and thinking about becoming financially eligible. So I think I've touched on pretty much all of the first two components that I wanted to bring up. And that's when I'll transition now into the third. So this unavailable asset bucket. As I said, it's pretty unique that you'll have an asset that falls under this umbrella or into this bucket. But the idea to describe an unavailable asset, it is an asset that cannot be made available to pay for care because it can't be converted to cash. Also known as I don't have the ability on my own to control it. If I or my spouse have sole control of an asset, it will not fall into this unavailable asset bucket. Okay. It has to be kind of somebody else outside of that married nucleus or my own nucleus. So a couple examples here. If you have a specialized trust, so there's a large number of different types of trusts, but if this trust is something that you do not have access to or you do not have control of, something like a supplemental or special needs trust, that is still for my benefit, but I can't reach in and direct those assets. The idea here is that would be an unavailable asset. It is not going to be counted against me. I will not be required to spend down every penny in that supplemental or special needs trust on my care. That's really why they're designed that way. But it is a pretty unique type of trust. This does not count. Minnesota has very intentionally closed the loopholes around trusts. As an example, I have a ton of clients that come to me and say, well, my aunt, my grandmother, my grandfather, my old neighbor who lives in X state uses a trust to protect their assets and is receiving Medicaid. And I have to explain, well, Minnesota must be just a tad bit smarter at a governmental level because they no longer allow us to use those tools, at least in the same fashion. So using an irrevocable or a revocable trust, at least in Minnesota, does not protect assets from this type of financial eligibility analysis. It has to be those very specialized trusts. A second type of unavailable asset can be an inheritance. Now, it isn't an inheritance that I've received because that obviously becomes something I can control and liquidate and it is available. But if it is pending, if it is in a pending estate administration, probate, trust administration, and I can't push or compel that distribution today, we can list that as an unavailable asset and I can become eligible. Here's the kicker with that type of asset. If down the road in the future, that does become available to me, it distributes to me as the medical assistance recipient. Now it is an available asset and I'm going to lose my benefits because it will make me go over the $3,000 limit that I discussed earlier. And it is converted from unavailable to available. Okay. So that's where we can cause some issues or some problems if we're walking through this process. And it isn't uncommon for a medical assistance applicant or recipient to have to go through the process multiple times because of fluctuations in their assets. Ideally, working with an elder law attorney, you avoid those fluctuations where possible. However, it can definitely happen where you apply for medical assistance and go on and off benefit more than once. A final piece that I will bring up for my unavailable bucket here is real property. So I discussed the fact that a secondary or third home, vacation property, cabin, etc., is going to be deemed available. However, if I own this property with somebody else that is not my spouse, so if I own it with my family, siblings, my parents, somebody random, a total third party, maybe hunting land with some friends. The idea here is if they are refusing to sell and are not going to, for some reason, going to be able to purchase my portion of that property, and I can't force them to sell or force them to buy my ownership interest. So an example is a joint ownership situation where I own all of it and they own all of it. It's not a fractional interest. Then that property can be deemed unavailable. So for very narrow circumstances, certain real property, secondary or third real property ownership interests can be considered unavailable and allow someone to become eligible for medical assistance while they still have that ownership. So now I'm going to start drilling down. Both of my previous slides were the umbrella. They aren't totally specific to medical assistance elderly waiver, but they are medical assistance in a broad sense, Medicaid in a broad sense, the entire umbrella. So this is one specific area of programming that medical assistance authorizes. So what is it? What is elderly waiver? Well, it's one of the programs under the home and community-based services portion of medical assistance. So the idea here, or the idea when medical assistance was created, when Medicaid was created, is that it was really designed for people receiving care in nursing facilities. So it had what I would call a little bit of an institutionalized bias. It didn't like to try and pay for, and it may not have been accessible by people that wanted to receive care in home or that were in independent or assisted living and didn't have quite the full-fledged skilled care needs. So this home and community-based services section of the law came out under, as you'll see on the slide, 1951C of the Social Security Act of 1981, excuse me. And what this really did is it created waiver programs. And waiver programs are designed to offer a broad range of services to people who otherwise would have been institutionalized. So the idea was to break apart that bias, make it so that there is more accessibility for payment of care so that I don't need to go into a skilled nursing facility. I don't need to be in a nursing home or memory care to be able to receive access to some of these benefits. So elderly waiver came into existence. Elderly waiver, as I touched on with the previous slide briefly, is designed for the funding of services in the community. So that can mean your home, that can mean independent senior living, and that can even mean assisted living because that is not full-fledged nursing care. However, it is specifically for individuals over the age of 65. Okay. I remember that I put in and said in that one slide that one of the base eligibility criteria for medical assistance was that you're over the age of 65. So you're saying, Josh, that just makes sense. Well, there is some programming available for those under age 65 that are also considered home and community-based services. Those are considered CADI waivers. So that's not necessarily what this section or this presentation is designed for, but CADI waivers or community access for disability inclusion waivers are so that disabled individuals under that threshold age can also access some of these programs. All right, I'm going to shift and kind of highlight now, as I believe I have about 20 minutes left here, some of the requirements or specific differences in relation to elderly waiver services. So, as I've said, and I might sound like a broken record, but it becomes very, very important as you walk through these processes to know it. A medical assistance elderly waiver recipient, or MAEW recipient, must generally qualify for medical assistance. So all those base level criteria still apply, okay? Big difference is my however bullet point right there, my second bullet point. However, the services provided to a person on EW must be provided for less than the cost of care in a nursing facility. So let's back that sentence up a little bit. The idea here is that it makes sense. The state of Minnesota is willing to offer me on elderly waiver. They're willing to make up the difference that I can't pay for in my care at home or in assisted living, so long as it doesn't cost them more to do so. So the idea here, or if you think about it, is nursing level care is 24/7 care. That means there's always someone there to help or check on you or provide for your needs. If you are looking to receive 24/7 care at home, it is very unlikely that the state of Minnesota is going to be able to pay for someone to provide that care individually, specifically to you at home, versus receiving that care in the nursing facility where one staff member can provide that same care to a multitude of people. So, with that being said, you must be able to show and go through again another nice little mathematical formula that what you are asking the state, the county to pay for under the elderly waiver program costs them less than if you were to go into a nursing facility and just go on straight medical assistance. Okay, so that's another threshold kind of financial issue that is involved specifically with EW. Finally, it's a little bit of a weird one and one that people don't always think about, but the law does say the elderly waiver recipient, MAEW recipient, must be able to receive services in the community and make the active decision to do so. So, being able to receive it. This can get to be a little bit more difficult and challenging if you are in rural communities. If you are not able to receive that care, you can't get someone to provide it, whether it's a family member, a spouse, a professional care team, something like that, and you aren't able to stay at home or stay in the community, unfortunately, elderly waiver is not going to be a program that's for you. The final piece here, and this changes over time. So as I interact with people that have been involved in elderly waiver or have had family members on elderly waiver in the past, this part may change. But you actually have to go through a little bit of an additional hoop when you apply. So when you apply for medical assistance generally, or medical assistance for long-term care, the process isn't as nuanced when it comes to assessing your care needs. But if you are going the elderly waiver route, you actually have to go through a specialized assessment that demonstrates your care needs and demonstrates or gives a little bit of an indication as to the expense or cost, okay? So that can be called a long-term care consultation, LTCC, but it has been known by different names and different types of things. A care assessment, there are very interchangeable terms. But the idea is that in conjunction with your medical assistance elderly waiver application, You also have to enlist and touch base with the county that is going to provide the services to say, hey, can you come out and meet with me, meet with my family, and have a dialogue about my care? Okay. That is a necessary and required component of the elderly waiver program, in addition to the overall medical assistance application. So I've touched a lot about becoming eligible, what the process looks like. The application itself you can find online or find through your county so you can look through it. But once I'm receiving benefits, once I'm on benefit or receiving medical assistance, what do they pay for? What can I even use these funds or attribute these funds towards? Well, it's actually a very, very extensive list. And while I took this one directly from the law and the policy manual, you can break these apart and they account for additional things. So if you have a question about any one of these specific areas or definitions or types of services, go ahead and look them up and you'll be able to feel that out. Adult day services, case management fees, chore and companion services, caregiving like home health aides, even things like home delivered meals and homemaker services. There you'll see home and vehicle modifications on the top of my second column here. That one's a little bit unique and I paused slightly there as I pointed out because you may need permission as you go through some of this, or you may need to work with specialized contractors or vehicle providers. So if you're going to be looking at receiving benefits that pay for modifications to your home or updates or modifications to a vehicle, you always need to basically ask for permission first when you're on benefit. So the idea there is don't just charge forward and buy it and then expect to be reimbursed. Make sure you ask permission instead of beg forgiveness because the government isn't the most forgiving entity. Next, you'll see, and I'm going to move my head out of my way on my Zoom here so that I can continue reading them off for you, but is individual living supports, non-medical transportation services, personal emergency response systems like those pendants or something like that, PCAs, residential services, skilled nursing visits, specialized equipment and supplies, and finally transitional services. So again, that list is very broad and can actually pay for a large volume of things that people may not initially think of when they think of Medicaid or medical assistance. So it's a really good idea if you're contemplating the EW program to actually go in and try and break apart some of those kind of umbrella terminology, such as something like consumer directed community supports. Well, what does that mean? What can it actually pay for? As I transition here, I think I'm about 10 minutes left, the 10-minute mark. So I'm going to talk a little bit about asset transfers. And this should always trigger two words or phrases. The first word is gifting. And the second phrase is the look back period. Okay. And most people that are contemplating medical assistance, that have worked in medical assistance, or that have had a family member engage this at all, have heard of those two concepts. So the idea here is first, certain transfers are allowable. Certain quote unquote gifts are allowed. Transfers between spouses. So if I make an asset transfer to my spouse and I don't ask them to pay me for it, well, that may be a gift to that spouse. Because we are married and we have that legal relationship, that transfer isn't going to trigger any kind of penalty or scrutiny. Okay. Also, as I discussed in the slide that talked about available, unavailable, and exempt assets, you can convert assets from an available designation to an exempt designation. So buying something for yourself, buying more household goods, buying a prepaid funeral and burial policy, buying a new vehicle or a new home or paying off debt, all of those types of things and strategies, those are allowable transfers. You're not going to receive any pushback from the county when you do something like that. Finally, an allowable transfer that obviously isn't a gift because it's a purchase agreement. But if I have my home and I can no longer stay there and I'm a single individual, so it's going to count against me. It's going to become an available asset. I can certainly sell my own home and I can sell it to whomever I want. I can sell it at large in the community, but I can also sell it to a family member or a friend. The issue here is I can't cut them a sweetheart deal, and I certainly can't give it to them freely. If they purchase it from me for fair market value, here's what happens. I give them the tangible or physical asset, and I receive the fair market value proceeds, the cash. Then that cash becomes available to me, and I have to spend down or reduce those assets. Okay. So maybe I've been able to transfer the asset and keep the actual family home as a family asset, but I still need to reap the benefit and be paid for it. Okay. That's an allowable transfer and it doesn't generate a penalty. It just really increases my available assets. What do we really care about? What do most people that watch or come to presentations like these have in the back of their mind? Well, what isn't allowed? What triggers a penalty or causes a problem? Those are transfers that are under this secondary heading called transfers triggering a penalty. So when I apply for medical assistance, the application itself asks me, have I made gifts of anything? Have I made transfers to anybody for less than fair market value in the last 5 years or 60 months? That time frame, that time period is considered the look back period. So from my date of application that I'm asking the county to pay for my care, pay for the difference in my care for my income, I need to report and I need to look back 5 years and make sure that I have not made any transfers of assets that would be considered a gift and therefore penalized. Okay. So within this, the idea is it is my responsibility to report those gifts. Okay. And it is a gift of any value. When I gave this presentation in person, one of the audience members said, well, wait, what about the gift exclusion? What about the $14,000 or $15,000 gift that I can give? Doesn't that not count? And the answer is absolutely not. It does count. It counts against you. And technically, the law says any gift, whether it's hundreds of dollars or thousands of dollars, is going to be countable within that 5 year period. Okay. So the $15,000 gift exclusion is more of a tax thing. It's more of a, if I give a gift worth more than that, and I'm not considering medical assistance or Medicaid programming, if I go over that watermark, that high watermark number of 15,000, I have to let the IRS or the Department of Revenue know that I gave that gift during that tax year. Okay. That's where that number comes into play. It has nothing to do with it. It has zero bearing on planning for Medicaid or medical assistance. So I already kind of said that that 60-month, 5 year look back period is triggered or begins on the date of my application. So basically what that means, if you look at it from a forward thinking perspective, if I were to gift $10,000 to a family member and I did not want that to be clawed back or looked back upon when I apply for medical assistance, that means I need to wait 5 years from the date I give the gift to go ahead and arrange for an application to be submitted on my behalf. As I said, any gift at all, any dollar amount is going to result in a penalty period. What is a penalty period? That is a period of time where if I give a gift and then I apply for medical assistance is going to run a formula. And they're going to say, based upon the dollar amount that you gave away or the value you gave away, we will not pay for your care for X amount of months. The way they do that is they take the gift value, so in my example, $10,000, and then they take what they consider the average monthly cost of care. So it's a number that gets updated every year. And they say, okay, for the average Minnesotan, care costs $8,000 and change. Josh gave away $10,000. So we're going to penalize him a month and a quarter. Okay. So I would not be able to, I would have to find a way to have either myself, a family member, or somehow pay for care for that penalty period time. Okay. I do have that specific number written down here in my notes, I believe, and I will go ahead and provide it. So again, I told you it's the statewide average in Minnesota of a cost of care in a skilled facility. So it has another fun acronym. It is called the SAPSNF, SAPSNF, And right now in 2021, that average monthly cost of care is $8,412. So that would be what my gift would be divided by to generate a penalty period. The final section I have here, and I believe I have just a handful of minutes, 4 or 5 minutes here that I will go through unless Terry wants to jump on afterwards and ask any additional questions or if he has any additional thoughts. But the idea with this slide is post-death recovery. And it's something that if you're not an elder law attorney or you don't deal in elder law, it's the most commonly overlooked portion of the practice or of the program. So most people think about it's so painful that I have to spend down my assets and I can't give them away. I can't pass them on to family members. And they think about that as the pain of the program. Well, I always like to highlight in my closing slide here that the benefit is for however long you live and you're on medical assistance, thousands and thousands of dollars of care can be provided to you for the rest of your life. So if you think about the average cost of care being $8,000, okay, 8,400. So let's round up to 8,500. So I'm just going to pull out my handy dandy calculator here and punch in a few numbers to kind of provide for you a little bit of an idea of the benefit provided. So if my average cost of care is $8,500, that means annually, each year, if the state is paying for that entire cost, they are paying over $100,000 annually. If I am a moderately healthy person and I am expected to live for 5 or 10 years, obviously, if we multiply $100,000 times year after year, reaching 10 years of care in that nursing facility at that rate, we would be looking at over $1 million of care provided by the state of Minnesota. So truly, that benefit can be exponentially more than the assets that we end up spending down or paying. Here's the kicker, if you will, or the final piece that I wanted to touch on. There's a process called estate recovery. So if you go back to my example where we had a married couple, the idea is we shift as much assets as possible into the healthy spouse's name. And at the end of my life, I'm on benefit for 10 years. The state or the county is paying for my care. I pass away. The state is not simply making those payments to the facility and saying, you're welcome, Josh. They are keeping track of those. So my monthly expenses that are paid as my care costs go like this throughout my lifetime, probably more like this. They are keeping a receipt, if you will. They're keeping a record of a monthly transaction. They're showing how much they paid for me as they did throughout my lifetime. If my spouse goes on care and has to go through that same asset reduction, they begin keeping tabs on their cost of care as well. But for sake of my illustration here, let's say my spouse remains healthy throughout their entire lifetime. They never require medical assistance services, okay? Here, I die first. Nothing happens because my surviving healthy or community spouse doesn't have to pay for my care. Remember those assets we protected for them during their lifetime? They are exempt. But my receipt stays there. And upon my community spouse or my healthy spouse's passing, at that point in time, medical assistance does have lawyers similar to me, elder law attorneys, kind of, and they show up at the probate or the estate proceeding of my spouse. And they say, okay, Josh's spouse, we realize that you protected all of these assets by doing some appropriate legal elder law planning. But now that you are no longer alive to protect the house, to protect the $130,000 and change, the vehicle, etc., we are going to show up at your estate proceeding. And instead of those assets flowing down through your will or your estate plan to your children, they are going to bring a claim as a creditor. So the idea is the X amount of dollars that they paid for in my cares will then be paid for, at least partially, by my estate or my spouse's estate. So what does that mean? That means if I received $500,000 of care over the course of my lifetime and I pass away, and then my spouse stays healthy, doesn't receive care, and passes away, and the entire value of the estate, the house plus all of her available and liquid assets, is $500,000, medical assistance will likely recoup almost the entirety of the estate. They'll show up with their $500,000 receipt, give it to the personal representative of the estate, and say, this is what we are owed. Of course, there are certain types of creditors and things that may compete with the medical assistance claim, but generally they are a relatively high creditor and are likely to recoup against the estate. If the spouse's estate somehow or another has a large amount of assets compared to the claim will be paid in its entirety. If the estate is insolvent and doesn't have enough assets to pay for the medical assistance claim, then we will have to look at the creditors that exist overall, and the claim may be partially paid. A thought behind this, and another thing that makes people more comfortable moving forward, is that if you think about the way that care costs accrue over time, how quickly that dollar value can be very, very high. If your estate is relatively modest or low, the idea is that claim will never be paid in full. Medical assistance and the county and state government agencies that offer these programs rarely recoup the entire benefit that they have paid out. That is again why it's considered a welfare or a needs-based program. So I kind of delved into estate recovery and what happens after you've received benefits. I touched on and worked through a little bit of once I'm eligible and receiving benefits, what can medical assistance or medical assistance elderly waiver pay for or pay the facility for? And then I right away tried to describe and walk through a little bit more, what does becoming eligible for medical assistance look like when I fill out the application? I also touched on just most recently gifting and making transfers and how the look back period, that 5 year period, is instrumental in understanding and becoming eligible for medical assistance so that you don't penalize yourself or a family member or create an issue. Because, and this is the final thing that I'll say here because it just popped into my mind and I forgot to bring it up earlier. If you give away your assets and attempt to become eligible for Medicaid or medical assistance, and you can't make it that 5 years, either you will be penalized or you will have to ask for that gift back, and that those assets will have to be returned to you and then liquidated or spent down. So the idea is planning prior to that 5 year window is crucial and is the best way to prepare for becoming eligible for medical assistance or Medicaid. So getting to talk with someone like me or somebody else in my office, Rochelle in my office is an elder law attorney. And there are a handful of elder law offices in the state. But I would urge you, if you think this is something that is going to be on your radar or on your client's radar, to get in early. Don't wait until it's an emergency situation, because if you're within that 5 year window, your planning ability is hamstrung. Absolutely. And the likelihood of being able to protect any assets or make any transfers that don't harm your eligibility is very, very low, very minute. You don't have many options available. So plan early, think this process through, connect with an elder law attorney, and also elder law attorneys and estate planning attorneys are kind of very, very similar rules. But an estate planning attorney is really looking for wealth preservation and transfer, while an elder law attorney is looking at programs like this, government programs, Social Security, Medicaid, medical assistance. Um, so you want both of them or someone that practices in both areas on your team. You can certainly seek out people that have those types of elder law expertises and experiences, but be very wary when you're working with someone as a general practice attorney or just an estate planning attorney to make sure that they truly understand the fundamentals of medical assistance or Medicaid and any other government programs that you may have access to, such as VA benefits, because there's a lot of them and they're complicated and they change annually. So that's kind of my final plug for elder law in a broad sense. And I hope that I was able to kind of impart some very high level information in relation to Medicaid and medical assistance, and specifically elderly waiver. Thank you very much. I believe I'm probably right about at my hour mark. Um, Unfortunately, the recorded webinar, we won't be really in the neighborhood of asking for questions and getting any kind of back and forth with people that view this. Of course, you can always reach out to me. My contact information is on this slide. So if you have questions, if you have follow-up, if you need an elder law attorney or an estate planning attorney, I would absolutely ask you to reach out to Henningsen and Stocksville. If you like me and like the way that I provide information, certainly go ahead and ask for Josh. I'm the only one that works here, so I would be happy to help with any of your needs or questions. And I'm going to leave it on this slide and invite Terry to jump back in.
Thank you, Josh. Appreciate all your help with this. Because we are recording this for both professionals and families of folks that might be transitioning to elderly waiver, maybe I could ask the folks to write some questions in the comments and then send those to you, so you're not getting deluged with phone calls on for these kind of items. We can just handle it in one document, and I'll be glad to do that. But thank you so much, and I appreciate the time you've given us, and I think this is great information.
Absolutely, I appreciate the partnership. Again, he doesn't get to have his information up like I do, but that is Terry Collins. He works with Rose Arbor and Wildflower Lodge, and he is my connection there, and then the reason that you're getting this information. So thank you, Terry, for involving me.
Oh, glad to. Very much so.